As you know, I asked the jury to come in a little bit later today at 10 o'clock so that we could have our hearing on the order to show cause, which is identified as SMZ 71911 of 24. I looked at the exhibits that were provided by both the people and the defense. The people provided 4 exhibits, one for each one of those violations. The defense provided a number of exhibits, I believe it was close to 500 pages in total, and also submitted so people, why don't we begin with you going through each of the violations and explain to me why you believe that it constitutes a violation?
Sure, Judge. Unless Your Honor prefers it, I think that I will not play each of the video clips or even read the direct language. I will just talk about each of them, and I will let you know which one I am speaking about as I am speaking about it.
I agree you shouldn't play the video. You can give me the exact language and why you think it is a violation. You should do that.
Okay, Judge, I just want to start by saying the defendant's complaining that this order restricting his extrajudicial statements in this case was not intended to allow everyone to attack him, but not to allow him to respond, and that's on page 1 of his memo. The order was issued because of the defendant's persistent and escalating rhetoric aimed at participants in this proceeding. And the order was intended to prevent the defendant from attacking witnesses in this case, and jurors in the case, and others. He has already been found by the court to have violated the order 9 times, and he has done it again here. With respect to the first violation I'm going to talk about, this is actually the second violation on the order to show cause that we handed up. It's Exhibit F in the April 25th affirmation, and I will just start by reading it. The defendant said the following. But this judge said that I can't get away from the trial. You know, he is rushing the trial like crazy. Nobody has ever seen a thing like this. That jury was picked so fast, 95% Democrats. The area is mostly all Democrat. You think of it as just a purely Democrat area? It is a very unfair situation, that I can tell you. This was just hours before he had a hearing here related to his previous violations. He was on the media, and he used his platform there to criticize the seated jury in this case. There is no inference needed. It is not just any jurors, it is these jurors in this case, sitting right in this room in a few minutes. His contrived justification in his papers is that, well, the media was saying some of what I am saying. That's a little bit like his reposting argument, except weaker. The defendant saying anything amplifies it and creates an air of menace that is substantially different from a media report. By talking about the jury at all, he places this process and this proceeding here in jeopardy. That is what the order forbids, and he did it anyway. I will move on to the second violation that we are alleging, and it is actually the 4th in the order to show cause. It's Exhibit H in the affirmation that we filed on the 25th. That statement was made on the morning of the 25th. So, on his way down here for the hearing at some kind of a press event, I think at 49th and 5th Avenues in Manhattan. And the defendant was out, and there were reporters around who were asking him questions. I think that was all part of the plan. And one of the questions, and I will read now the question and then the defendant's statement. The question was, what have you thought of David Pecker's testimony so far? When was the last time you spoke to him? The defendant's answer was, he has been very nice. I mean, David's been very nice, a nice guy. This is a classic carrot stick. First of all, there is no question that there was a witness in the proceeding because the witness was going to be testifying an hour or two after the defendant made that statement. As I said the other day, the defendant knows what he is doing. He talks about the testifying witness, says nice things, does it in front of the cameras. To be clear, he was asked other questions about this case and ignored them. So this was not just the defendant responding to everything the reporters were asking him. He selectively responded to this question and not others. The one he answered was about the witness who was testifying. It was deliberate and it was calculating. Pecker, be nice. Everyone is hearing this. I have a platform and I will talk about you, so be nice. What the defense counsel described as innocuous statements about Mr. Pecker on page 5 of their memo is anything but. They are deliberate shots across the bow to everyone that may come to this courtroom to tell the truth about the defendant and what he did. Moving on to the third statement that I will talk about, which this time it is also the third statement in the order to show cause, and it's Exhibit G in the affirmation that I filed. This is from an interview that the defendant gave to a Pennsylvania TV station on the morning of Tuesday, April 23rd. It didn't actually air until that evening, and the statement is as follows. Well, Michael Cohen is a convicted liar, and he has got no credibility whatsoever. He was a lawyer, and you rely on your lawyers. But Michael Cohen was a convicted lawyer. He was a lawyer for many people, not just me, and he got in trouble because of things outside of what he did for me. Largely, it was essentially all because of what he did in terms of the campaign. I don't think there was anything wrong with that, with the charges that they made. But what he did is he did some pretty bad things, I guess, with banking or whatever. If it was a personal thing to him. David Pecker, I don't know exactly what he's going to be testifying against, but, or about. He will be testifying today. Again, no question this is related to this proceeding. The defendant is talking about two witnesses, one of whom was on the stand at the time in the middle of testimony. It's clearly willful, clearly knowing. The defendant thinks the rules should be different for him. I talked a bit about the impact of comments about a testifying witness. Perhaps not on that witness, but on other witnesses. It is an insidious thing. I will talk a little bit more about Michael Cohen in a moment. Moving to and again in that statement, he is talking both about Michael Cohen and his credibility, which is a theme here, and then about David Pecker, who is the witness on the stand. Finally, I will move on to the first statement in the order to show cause, which is Exhibit E from the April 25th affirmation. That was made also on April 22nd, earlier in the day than the statement I just talked about. And I know I said this the other day, that this statement was made right outside of these doors, the doors of this courtroom in the little pen that's set up where he speaks to the gathered media every day. He stood there for almost 9 minutes, and he talked about a prospective witness that was going to be in this courtroom at some date in the future, Michael Cohen. What he said was, and it's two different excerpts, but they called the payment to a lawyer a legal expense in the books. They didn't call it construction. They didn't say you are building a building. They called it a payment to a lawyer because, as you know, Cohen is a lawyer, represented a lot of people over the years. I am not the only one and wasn't very good in a lot of ways in terms of his representation, but he represented a lot of people. But he puts in an invoice or whatever, a bill, and they pay, and they call it a legal expense. I got indicted for that. Later, the defendant went on, quote, and when are they going to look at all the lines that Cohen did in the last trial? He got caught lying in the last trial. He got caught lying, pure lying. And when are they going to look at that? This and all of these are clearly related to this proceeding. They are clearly willful. The defendant is talking about witnesses and the jury in this case, one right here outside the door, all during the trial. This is the most critical time, the time the proceeding needs to be protected, particularly where defendant has demonstrated over time and recently his willingness to say and do anything he can to try to infect and disrupt this process. That's what the defendant has tried to do and continues to try to do. We understand the court's concern about Michael Cohen, but in the statements at issue here, the defendant wasn't responding to anything in particular. He talks about things Michael Cohen has said in the weeks and months before defendant's statements at issue here. There is mention of TikToks more recently, and now I will talk about the exhibits, the 50-plus exhibits, 500 pages of documents that were filed with defense papers. But there is nothing to indicate that the defendant saw those statements when they were made. This order has only been in effect for 4 to 5 weeks, not months. Michael Cohen is not a political opponent. Defendant's comments about Michael Cohen relate to issues at the heart of this proceeding and Michael Cohen's participation in the proceeding. They don't relate to political policies or goals of the defendant. The defendant is doing everything he can to make this case and the proceeding about his politics. It's not. It's about his criminal conduct. His statements are corrosive to this proceeding and to the fair administration of justice, as Your Honor knows. We just did this the other day. What we have to prove here is the existence of a lawful order expressing an ongoing mandate, which I submit is very clear here based on the court's previous decision and other litigation on this very issue. We have to show a violation of that order, and that's what we have just gone through. And we have to show that it is made with knowledge, and it is willful beyond a reasonable doubt. I would remind the court that on Monday, April 23rd, Mr. Blanche, in court with the defendant sitting right next to him, said the following about the defendant's knowledge of the order, and this is from the transcript on April 23rd, page 964, line 10 to 15. There is, just to set the record very straight and clear, President Trump does, in fact, know what the gag order allows him to do and not allow him to do. And there was absolutely no willful violation of the gag order in the 10 posts released by the campaign or what the people just discussed.
What was the page number on that?
Sorry, that was page 964, April 23rd, lines 10 to 15.
Thank you.
Again, the existence of a lawful order I don't think is at issue at all. There's been plenty of litigation on that. The court issued the decision the other day, based on the comments themselves, the timing, and even for the one comment, the location. I submit that we have met our burden and established that the defendant willfully and knowingly violated the lawful order of this court on each of the 4 occasions that I have just went through. We are asking the court again to impose the maximum $1,000 fine for each of the 4 violations. Because each of these statements was made before the court held the defendant in contempt for violating this order 9 previous times, and because we prefer to minimize disruptions to this proceeding, we are not yet seeking jail. But the court's decision this past Tuesday will inform the approach we take to any future violations. We are happy to answer any questions. Thank you.
None at this time, thank you, Mr. Blanche.
Thank you, Your Honor. So, part of my argument this morning does react to the court's order on Tuesday from April 30th, and while we disagree with the court's order to some context, we are guided this morning in what I am going to say to the court by what the court said to us on Tuesday. First, the purpose of the gag order, Your Honor, is to restrict extrajudicial statements in order to protect the integrity of these proceedings by shielding those fearful of reprisal by the defendant so that they may take part in these proceedings without concern. And as I will get to in a few minutes, Your Honor, that concept alone is reason enough to deny the 4 that we are here about this morning. And I know that the court has stated repeatedly that the gag order and Your Honor's intention is not to allow unfettered attacks on President Trump, recognizing he is running for president. Doing a campaign every day, part of the campaign takes place outside of this courtroom. Part of the campaign takes place in interviews, meetings with potential voters, whether there is press present and on the campaign trail, and Your Honor said it again in the order on Tuesday. And there is no dispute, I think, among anybody, the court or the government, that political attacks and responses to political attacks does not violate the gag order. And I disagree with the people. I disagree that the time that we start looking at what President Trump is responding directly to is the day of the gag order. Since President Trump announced his candidacy to run for election this November, in 22, almost 2 years ago, there have been multiple and repeated attacks on him from, among other people, Michael Cohen, and folks that Michael Cohen has on his podcast regularly. Again, to talk, I will get more into this in a minute from our exhibits, Your Honor, to talk not only about these proceedings, and not only about Mr. Cohen's credibility, and not only attacking President Trump's credibility, but also attacking him running for president, the qualities he would bring as a leader of this nation, and reflecting on the presidency 4 years ago.
If I can make a suggestion, Mr. Blanche, my main concern is the conduct that took place after the gag order was implemented. I looked at the exhibits that you provided. If you want to go through some of them, that's fine, but it's 500 pages.
I'm not going through all of them, Judge, of course not.
Just as you know, it's not going to weigh very heavily on my decision if you refer to exhibits a year ago or 2 years ago before the gag order was in place.
Your Honor, it is not my intention to do that. We will get to that in a minute. In response to the court's order on Tuesday, and in preparation for our hearing today, we are prepared to pass up some additional exhibits. And the only exhibits I am referring to today, I believe, are recent exhibits that bear on the 4 charged counts. But Judge, I do think it's appropriate when the court's considering whether there has been a willful violation of the gag order beyond a reasonable doubt, to keep in perspective beyond just the gag order. Your Honor did that in reaching the conclusions. That's what I'm talking about today. That's it.
I am telling you what I am going to consider when I make my decision. You can do that.
Judge, last weekend, President Trump's rival, President Biden, said in a public forum, he talked about this trial and he talked about a witness that's going to be in this trial. He mocked President Trump. He said, Donald has had a few tough days lately. You might call it stormy weather. Okay, President Trump can't respond to that in the way that he would want to because of this gag order. Stormy weather is everyone...
Where?
It's one of our exhibits, Your Honor. Stormy weather was an obvious reference to Stormy Daniels.
You are saying that he can't respond to what President Biden said without saying Stormy Daniels?
That's exactly what I am saying. He cannot respond without saying Stormy Daniels, Your Honor. He is not allowed to.
No, He is not allowed to refer to a foreseeable witness in the case. He is certainly allowed to respond to something said by President Biden. There is nothing in the gag order that says he can't.
Your Honor, I am not saying that he is not allowed to respond to President Biden, but he is limited in what he can say. President Biden is not limited. So President Biden can make a reference to this trial and to a witness in this trial. President Trump can respond about certain parts of this trial, and, Your Honor, that's just my opening point. That happened this past weekend is to give context to the 4 statements, which is the reason why we are here today. In addition to the exhibits that were attached on Monday evening, Your Honor, we are also going to hand up to the court and the government shortly exhibits we will offer, and they are Exhibit 61 through 126. These exhibits are mostly tweets or retweets by Michael Cohen recently, certain mea culpa podcasts, recent ones, and I don't believe everyone since the gag order, but recently, and then certain video transcripts from news programs regarding Mr. Pecker's testimony, the jury composition, and Mr. Cohen himself. And I am not going to go through all of them. I'm going to highlight a few of them before I offer them up, and I have a thumb drive with all of them.
Okay.
Thank you.
Whereupon documents and a thumb drive were handed to the court and the people.
Is there a reason why this wasn't provided before when you submitted your answering papers?
Yes.
What's that?
The additional exhibits are in response, as I mentioned a few minutes ago, to Your Honor's order on Tuesday, because Your Honor made plain in the order, recognizing that there would be opportunity, and it may be necessary to allow to remove certain people from the gag order if they didn't need to be protected. That's the reason that we are coming at it late, Your Honor. So I am going to go in a little bit reverse order and talk about Mr. Pecker, the alleged violation regarding statements about Mr. Pecker. So what President Trump said, David Pecker, I don't know exactly what he is going to be testifying about, but he will be testifying today. So that was a recording, as the government just said, on April 23rd, for a news show in Philadelphia. It aired about 6 o'clock that evening. That was in response to a question from the interviewer saying, "Where is your concern level at this point regarding David Pecker's testimony and Michael Cohen, but focusing on David Pecker for now? Where is your concern level?" President Trump sidestepped the question. He gave a very factual, truthful answer. It wasn't a warning. It wasn't a commentary on what Mr. Pecker had testified about, and certainly it was not a willful violation. I mean, he is talking, as the court knows from the testimony, about a man that he has known for decades. He is talking about a man who he was friends with for decades. There is no threat. There is no threat in what President Trump said, and we cited 10. There are multiple articles. We cited 10 of them in our papers, news articles that are going into excruciating details about Mr. Pecker's testimony. So when you have President Trump in response to a question saying something completely neutral about the witnesses, that's not a willful violation of the gag order, when the intent of the gag order is to make sure that Mr. Pecker comes in here and testifies without fear of what President Trump has said or will say.
It's not just about Mr. Pecker. It's about what all the other witnesses who may come here see. If the witnesses were to see Mr. Trump speaking about Mr. Pecker or even Mr. Cohen, it affects those witnesses as well. And that's why I understand your concern of Mr. Cohen. I expressed concerns about Mr. Cohen and Ms. Daniels in my decision, and those are valid. I get it. But it's not just about those individuals. It's about what everybody else, the jurors, and all of the other witnesses see Mr. Trump saying or not saying about other witnesses, and that's a concern. That does go to the integrity of the proceedings.
Your Honor, as applied to this case and this trial and what's happening behind us, that's the reasons why this gag order isn't fair.
When you say behind us?
I'm talking about the press and the fact that there is 24/7's coverage of everything that's happening in this courtroom and everything that the witnesses are saying. And so every time we whisper to our client, it's live streamed over all sorts of social media outlets, every word the witnesses say. And so then you have President Trump, who is asked a question. Everybody is talking about it. What do you think of his testimony? And he doesn't say, I think he is a liar. He better watch out. He says something. He can't just say no comment. Repeatedly when he is running for president, and I appreciate the court's concern, very much so. And we are reacting to what Your Honor wrote on Tuesday, but it's also appropriate to turn to what's happening with this trial.
What's happening in this trial is no surprise to anyone. I mean, the former president of the United States is on trial. He is the leading candidate for the Republican Party right now. It's not surprising that we have press here. We have press in the overflow room. There are people throughout New York that are interested. Everybody that came into this knew this would happen. We all suspected it. There are no surprises here. So I don't see how it would press on Mr. Trump if 10 outlets are talking about Mr. Pecker.
Judge, the reason for the order is to make sure that witnesses that are going to come in here and testify are going to do so honestly and without fear of reprisal. And my point in reflecting on the intense scrutiny of every word said by every witness is that everybody can say whatever they want, except for President Trump.
They are not defendants in this case. They are not subject to the gag order. That's a very significant issue that you are overlooking. I don't have authority over the press. I don't have authority over most of the people that are saying things. I couldn't possibly extend a gag order to them. I just don't have that authority. So I don't see the comparison. I don't see the analogy between comparing your client, who is the defendant, and who is subject to the gag order, with 10 members of the press who wrote an article.
I am not asking Your Honor for an analogy. I am not comparing one to the other. I am saying that when Your Honor is considering whether President Trump has willfully violated the gag order beyond a reasonable doubt, it makes sense. The court has to look at what all the press and all the media and what Mr. Pecker was reading about his statements. And so, when you look at what President Trump said about his statements, it does matter. It matters to the willfulness, and it matters to whether the reason for the gag order is.
If I may, I would like to ask you a question, and this has to do with what you are talking about. If we look at the first exhibit, I don't remember the exhibit letter, so I will call it number 1. When those statements were made, it was your client who went down to that open area and stood in front of the press and started to speak. It wasn't the press that went to him. He went to the press. He didn't need to go in that direction. The door that he uses is to the right, so you are telling me that, the scrutiny is outrageous. Nobody forced your client to go stand where he did that day.
Judge, I agree with that, but 2 responses. 1, there is a much different reason with respect to Mr. Cohen, which I will get to in a minute. And 2, nobody is forcing him, but he is running for president. He has to be able to speak. So Your Honor is right. He can walk out there and go right, or he can walk out there and go left, and make a statement which he is entitled to do, and has to do, Your Honor. So we are not.
That's why he is being allowed to do that. That's why that entire area has been set up the way that it is set up, to ensure that your client, as a candidate for presidency, has the opportunity to speak about absolutely anything he wants, including the district attorney of New York County. But there are just some things he cannot talk about.
Your Honor, I'm going to talk about Mr. Cohen in a minute. I want to address briefly the second Pecker statement, which is Exhibit H to the People's Affirmation. And this statement is, President Trump is asked the question, what have you thought of David Pecker's testimony so far? When was the last time you spoke to him? President Trump said, he has been very nice. David's been very nice, a nice guy. And again, he is responding to a question. Mr. Pecker had been on the stand for 2 days at this point. The government says that that's threatening and a warning to witnesses that they need to be nice. That's just not true. He is just responding to a question and saying he has been very nice. Your Honor observed his testimony. There is no animosity between the two of them. There were no threatening or menacing statements. Again, Mr. Pecker himself testified about their friendship and the relationship, and he would call him Donald, and that he had a great relationship with President Trump over the years. And we again put multiple articles in front of the court, again not to compare, or not to say that that alone gives President Trump the right to say something, but when the court is considering whether the purpose of the gag order was frustrated by, he has been very nice. He has been. David's been very nice. It does matter.
Just to save you time, I am not terribly concerned with that one. I think that there are situations where comments like that could be of much greater concern. At this moment, based on what I saw and heard, I am not terribly concerned.
I will stop with that. I will talk about Mr. Cohen and the defendant. Judge, there are 2 statements the government. Read. One was outside of the courtroom and one in response to an interview. Again, the second one was on April 23rd. And Judge, Mr. Cohen and I am going to spend a few minutes on this because it's extremely important. In my view, the most significant one has been inviting and almost daring President Trump to respond to everything he has been saying. Again, personal attacks on his character, mocking him for being on trial, and also his candidacy for presidency of the United States. So I just want to put a few up on the screen.
Very quickly, please. I want you to make your argument.
Sure. So, Exhibit 39, this goes to Mr. Cohen mocking President Trump on X. If we can go to page 2 and then 6 and 7, just very quickly, if we can blow it up a little bit. For the record, it has a photo of President Trump in an orange jumpsuit with a picture next to Nelson Mandela, and it's just a long repost by Mr. Cohen criticizing President Trump. And then we can turn to page 6 and page 7. And again,
What was the date on that?
that date, Your Honor, should be up at the top. April 8th of this year, Your Honor. And then pages 6 and 7, it's more of the same. If we can focus on the date, please, at the top, April 14th. And again, keep messing with me, Donald. And I won't send any money to your commissary. A comment by Mr. Cohen. And then something obnoxious. And then on page 7, at the top with the date first, please. And this is on April 16th. Please don't forget about the witnesses. We also matter. Reposting a photo of President Trump. Next, if we can turn to Exhibit 64, quickly, please. And this one, Mr. Cohen, this one says, "Oh my, shits in pants. Keep whining and crying and violating the gag order, you petulant defendant. This was sent after the gag order was put in place. Exhibit 67, please." Again, from Mr. Cohen criticizing, again, your attacks on me stink of desperation. We are all hoping that you take the stand in your defense with a picture of President Trump in this courtroom. And again, that is on April 22nd. And then finally, Exhibit 110. Again, this is before the gag order, Your Honor, April 4th. But again, this is not necessarily Mr. Cohen criticizing President Trump about this trial, but about his business and his business ventures, Your Honor. So again, there is a lot more. We picked 4 out of a hat. They are all in kind and all similar. So the response, and now we are here again on a violation of the gag order as it relates to Mr. Cohen. These are responses to repeated and consistent attacks by him against President Trump, his character, his viability as a candidate. And as you can see, Your Honor, it's also completely throughout the Mea Culpa podcast and on TikTok, there are repeated attacks on President Trump's candidacy for president by Mr. Cohen. And if we can go to page Exhibit 63, and page 2, he is not just doing it to attack. I mean, there are repeated reports, and indeed they are true, that Mr. Cohen has been shopping television shows based upon not only what he did for President Trump, but also what he has been doing here. And he is talking about that and advertising what he is trying to do. And then, again, there is multiple examples of this in our exhibits. If we can bring up page 37, Exhibit 37, page 7, this is an April 12th political article quoting Mr. Cohen, talking extensively about President Trump's candidacy for president, criticizing him as someone that should not be voted for. On the same article, next page, it says, "Donald does not know how to tell the truth. He lied so many times. He can't keep track of the lies." And then just very briefly, Your Honor, and I hope the point has been made, but
You made your point. You made your point.
well, okay. But, I mean, on top of everything that I just put in, there is multiple examples of the Mea Culpa podcast that are over the top about his character, about his candidacy for president, including multiple interviews with folks in this room, with reporters who just blast President Trump from what he did as president and what he would do if he is elected in November. Multiple. I'm not talking about 1 or 2. I'm talking multiple, in excess of 10, way in excess of 10. Finally, as has been reported, because it's true, Mr. Cohen has started going on TikTok nightly and literally making money. So, there is apparently a way you can make money with people doing things while they are watching you on TikTok. He actively encourages folks to give him money. You can see that he has made money. His TikTok repeatedly criticized President Trump. He said, as recently as April 29th, mocking and almost poking President Trump as it relates to the gag order, "I am not the defendant in a criminal matter, and I am not the subject of Judge Merchan's gag order. Donald is, right, and that is after criticizing him extensively. This is not a man that needs protection from the gag order." And when you look at what President Trump said about Michael Cohen out here, and then in response to the questions from the interviewer, he wasn't talking about his testimony at this trial. He was talking about his quality as a lawyer. He was talking about the fact that he was a convicted liar, that he had been prosecuted for lying.
Can I ask you to address the comments that were made about the jury?
Yes, that was my last. So, the government read the statement that it was a 15-second statement out of an interview that was over 21 minutes long, and this was right in the middle of the interview in response to a number of questions about policy. And we can exclude the entire interview, but the policy, first about the types of questions that mattered to voters. But this trial matters to voters, so there was a question about this trial. As you know, Your Honor is very well aware, we very much believe that this is a political persecution and this is a political trial. And part of that belief and part of President Trump's belief is the location of this trial. The fact that he is being tried in a jurisdiction that is over 90 or...
Did he violate the gag order? That's all I want to know.
I'm making an argument that he didn't and laying the foundation.
So I am not accepting your argument, which is why I am asking.
Absolutely, positively not.
He spoke about the jury, right?
Pardon me.
And he said that the jury was 95% Democrats and that the jury had been rushed through. And the implication being that this is not a fair jury. That's the implication that was given to anybody that heard that comment. This is not a fair jury.
The gag order specifically references any prospective juror or any juror in this criminal proceeding. So he wasn't referencing juror number 4 is a Democrat, or, which by the way the press has noted and the press has highlighted, and the press has put on the screens who is Democrat and who is not registered. Again, he is talking about, again in a passing phrase, about the overall proceedings being unfair and political. The jury...
Okay, it's 10 after 10. Is there anything you would like to say just to wrap it up?
Judge, again, we move to the jury, and I am done with Mr. Cohen. But Mr. Cohen, and the same things in our papers with respect to Ms. Daniels, where, when you go back, the court goes back and looks at the purpose of the gag order, as opposed to just blindly looking at the statements that are made by President Trump. It's not violating, the constitutional limits that you put on the gag order, that Your Honor put on the gag order, are for good reasons. Because President Trump has to be able to talk extensively and to respond to questions in a way that don't violate the integrity of these proceedings. And as we said today, Mr. Cohen should not be part of this gag order. He does not need to be protected. The same is true for Ms. Daniels. She is not part of the 4 statements, but she is very similar, although not as voluminous, comments about President Trump personal, candidacy for presidency, and how he was president last time. They are not people that need to be protected, and to the contrary, he has to be able to respond to those, Judge.
I understand your argument. Thank you. Is there anything else on this point from either side?
No.
Let's take 5 minutes before we bring the jury in.